What's going on? I've got a Judge Simmons clip for you. We have a pro se, not a defendant. This is a civil case. So, but we still have a pro se, and this gets a little heated. Yeah, she's confused. That's all we'll say. She's confused. Judge Simmons handles it. Like I said, it gets heated. It's interesting. You guys know what to do. This is Colin. We're cooling. Let's go.
On the record in the matter of credit acceptance versus Ashley Brown, 22-013536GC. Appearance, please.
Good afternoon, Judge. Francesca Serby for Plaintiff, P87205.
Okay, you're Ashley Brown.
Yes, I am.
Okay, today was the date that was scheduled for a hearing. This is for an objection to periodic garnishment. We received an objection from you, Ms. Brown. It states that you are objecting to garnishment because you was improperly notified of any, does that say hearing?
Yes. So I did some research, and it appears that they reached out to a few of my other jobs like Kirchhoff, Champion, and I didn't get any notice of any of those. I feel like the only reason I got this one is because they sent it certified mail, and I handle all the mail for my new job here at the Funeral Directors Association. But they garnished my taxes. I was not notified of any of that. When I've only found out that they garnished the taxes when I called the courthouse when I received this notice, because I was like, because they did, I saw the taxes were taken, but I didn't really look into it. But then I called the court once I received the garnishment, and they were like, oh, well, they garnished your taxes for this particular matter. But I was never given any notice of that.
Did you want to respond to her objections, counsel?
Yes, Judge, I will. Plaintiff had the writ of garnishment properly issued. It looks like that was back in July, so July 23rd, 2025. The writ was issued by this honorable court and then served on Garnishee Michigan Funeral Directors Associations, Inc. There's no court rule or statute or case law upon which plaintiff is aware that plaintiff is required to give defendant prior notice of filing its writ for garnishment, but the writ was otherwise properly issued by this court. And plaintiff would further note for the record that it sees that defendant was the person who signed the green card on the delivery of the writ of garnishment, and plaintiff still has not received the garnishment disclosure pursuant to that, despite now having noticed that defendant is the person who signed the green card, as well as, her admitting in court that she got it. So plaintiff would ask that you deny the objection to garnishment as it's invalid. There's not a requirement that plaintiff's aware of that plaintiff has to forewarn a defendant about a writ for garnishment that was properly issued.
But you are still required by Michigan rule to notify me to, I'm sorry.
Ma'am, that's not how this works. You see how I asked her if she wanted to respond?
I understand, I'm sorry.
Okay, that's why I'm here. I'm the referee here. I get to mediate this. So you don't talk back and forth, you talk to me. So the court rule for your objection to garnishment is very clear. And there's no court rule that allows or tells you that you can even file a garnishment. That you see where you request the objection and it gave you a section A, B, C, D, E, and F. Okay, and that's because those are actually the only ways in which the court rule allows you to object to a garnishment. You checked F, which allows you to say that the garnishment or the writ of garnishment was issued improperly or otherwise invalid, and then you wrote in that it was because it was improperly notified of any. You wasn't properly notified of any hearing. There's no hearing that comes with. You're opening your mouth to talk over me while I'm talking. There's no hearing that comes with a writ of garnishment. I don't know what hearing you were looking for. There would have been no hearing. The other thing is you said that it was not issued or that writ issued after the initial hearing. Again, I don't know what you mean by initial hearing.
It's my turn to speak, I'm sorry.
That's correct. Yes.
So I was when I wrote this, it's because I literally was not notified of any other hearing even leading up. That's what I meant by hearing. So like I understand that they issued the writ of garnishment, but I was never notified about a hearing for the judgment or any of these other garnishments. How am I
Oh,
supposed to respond to a garnishment if I don't have this, if I wasn't served?
ma'am, you were served with the lawsuit in this matter, correct?
Uh-huh.
And then you appeared before me back in December 1st, 2022. There was a joint pretrial statement that was completed. After that, you received your next court date. You were supposed to appear in this court on March 28th of 2023. That's over 2 years ago. You failed to appear. Default judgment entered against you
I did not
because
get
you failed
notice
to
is what I'm
appear.
saying.
You failed to appear. You knew you were being sued. You were properly on notice that you were being sued, and the court sent the notice to appear for your next court date. That came from the court, and it did not get returned back to this court non-deliverable. If your address changed from the time that this court case began, it would be your responsibility to then go and notify the court, but it doesn't even appear that your address changed. So notice was sent for you to appear in court on March 28th, 2023. You did not appear. Outside of that, wait, I'm not done yet. Outside of that, ma'am, and the court then sent a notice of a default judgment to that same address.
Did not receive that.
So the court itself sent multiple notices to the address on file notifying you A, to appear in court 2 years ago, B, that you failed to appear and a default was entered. Once that happened, that allowed you the opportunity, if you had responded to even the notice of default, you could have came back to the court and request to have the default set aside, but you never did that. And that's quite common. We get a lot of people that ignore that paperwork, and then we hear from them once it's time for their garnishments to take place.
Is it my turn to speak?
Yeah, we haven't heard anything we haven't received or heard anything from you on this file since October 12th, 2022.
I did not receive a notice for judgment. I did not receive any notice for judgment. I don't know if they were lost in translation because I was fighting the case. I definitely wouldn't have not appeared to that hearing.
Ma'am, you were advised by this court that you were doing a joint pretrial statement and that you would have some dates that would be kicked out from the clerk's office. You knew you were being sued.
I was advised of it, but that doesn't mean I was served.
What did you think happened after the next 3 years after you came to court? What did you think happened?
To be fair, like once I did receive the notice once I received the information about the garnishment, I honestly thought that they closed the case because they garnished my taxes. But I still was not notified of any of those things. I don't understand, like I said, how I'm supposed to respond, because I would have responded to the garnishment way before now had I known about it.
Your tax garnishment is what you're talking about?
Yes, they garnished my taxes, but I did not know that.
Okay, so and that's not even what you're here for today. You're here for a different garnishment, correct?
I mean, it's all of them because, like I said, that's not the first one that they did. They did multiple garnishments or at least attempts, but there was never any notifications to me. How am I how am I supposed to respond to a garnishment if I don't have any notice of it? I only responded to this one because I literally received a notice.
I don't know what you mean. How are you supposed to respond to a garnishment?
Just like with this objection, like I'm objecting to it, I'm responding to it. I did not receive notice of those prior things, and I've done research on this company. This is not the first time they've done stuff like this.
Right, but I recognize you're objecting to the garnishment, but you're not providing the court with a objection that the court can consider. The court rule tells you what objections you can use. There are no such thing. There's no such thing as a hearing. There's no such thing as a hearing for a writ of garnishment. You don't get a hearing for that.
To the hearing, like I stated, that was the judgment hearing. I did not receive notice of that hearing.
All right. What she's saying makes sense, but she's not listening to what Judge Simmons is saying. And now she's interrupting her being rude. Yeah, you don't do that, especially with Judge Simmons. Yeah, just watch.
That's the hearing I was referring to.
Okay, that
same
if I had
received notice of the judgment hearing, I would have appealed.
You cannot continue to talk over me. What I'm telling you is that same court rule tells you that you cannot use an objection to garnishment to attack the underlying judgment, which is what you're trying to do.
And I understand that, but what other premise can I go on if I don't have any notices? If I had gotten those notices, I could have objected earlier. That's my whole
What I'm
thing.
telling
Like,
you, you cannot object to a garnishment so that you can attack the underlying judgment. You're saying the reason why you're objecting is because you did not get notice of the hearing in which you got a judgment for. The
but it says that they have to serve you with these garnishments.
No,
It says
the
that
court rule says you can't do that. It says that you can't do that.
there are no rules saying that they have to serve you with the garnishment. Is that what you're saying?
It says the garnishment has to be properly issued, and it was.
But I wasn't served it, is what I'm saying. So how was it properly issued?
They don't have to serve you with a garnishment. They have to serve your employer.
Okay, so I don't understand then how somebody is supposed to respond if they don't have the information.
No, you were supposed to respond to the lawsuit, not the garnishment.
Ma'am, and I have already stated I did not even receive a notice for the second hearing.
But you can't use you can't object to the garnishment now.
We wouldn't be here though if I had received that notice.
The court rule is very clear. You cannot object to the garnishment to now attack the underlying judgment. Do you understand that part?
I understand that, but I'm saying
so why do you keep repeating that then? Why do you keep repeating the same thing?
All right, because what she needs to do is she needs to file a motion to set aside the default. And Judge Simmons isn't going to give her legal advice, especially if she's interrupting her constantly. You could tell Judge Simmons is getting a little frustrated here because of the interruptions. But yeah, you got to file a motion to set aside the default, and then you can fight the original case. That's the only thing you can do now. And she's citing court rules, so she's looking things up. Yeah, this is just one of those pro se's that doesn't understand, and she thinks she does. Not going to work.
I'm trying to get you to understand that it doesn't make sense to say that I can't attack the garnishment if I was never properly notified about the initial hearing. There wouldn't be a garnishment if I had been notified.
I'm gonna terminate this hearing if you don't let me explain this the last time. I don't have the issue of the misunderstanding. I know the court rule very well. The court rule very clearly states you cannot file a motion to object to a garnishment because you want to now argue that you missed a court date or you didn't get notice that had to do with the judgment. That's what the court rule says. So you are trying to say that you didn't get notice of the court date that you were supposed to appear for back in March of 2023. The court rule says you can't use an objection to garnishment to do that. I didn't make the court rule yet. That's just what the court rule says. Do you understand that?
Yes.
So
Judge, can Plaintiff respond?
You have not provided the court with a reason under the law that I can grant your request to object to the garnishment. Yes, ma'am, you can respond.
Okay, just to correct the record, Your Honor, it was actually a summary disposition judgment that was entered in 2023, and it was also entered pursuant to the notice of 7-day rule for entry of the order. So the defendant had notice to appear for that hearing through plaintiff's notice of a hearing. They had an opportunity to object to the entry of the summary disposition judgment. They didn't file a response to plaintiff's motion for summary disposition judgment. And as Your Honor had already stated, it's not a proper objection to writ for garnishment when you're attacking the validity of the underlying judgment under the court rules. So it's plaintiff would ask that you deny the objection is invalid and appreciate that you've done that.
I'm trying to explain so that the Ms. Brown can understand her concern, because I'm not saying that there's no other avenue for you to go and try to figure out what happened with your notice or.
Ding, ding, ding. That's what I was saying earlier. She needs to file a motion to set aside the default. But the judge isn't going to tell you that. So, talking under your breath, you're not going to win any sympathy from the court that way. So, yeah, that's all I'm going to say. We're going to let this one finish up. This is perfect time. Just let it go. You guys are awesome. Thank you so much for watching. Hit that like button. I would appreciate it. Subscribe, leave a comment, all that fun stuff. You know what to do. But that's it. That's all I got. Until next time, bye.
According to what they filed, you were served with a notice for your date to appear in court. And outside of that, you knew you were being sued. And so when you appeared in my court in 2022, there shouldn't be a next appearance 3 days later, or 3 years later, that is. You should have appeared at some point wondering what was going on with your case because you knew you were being sued. And they had served you with discovery. They had served you with a summary judgment motion, which the court told you when you saw us would have a deadline date. And so we advised you of that when you were last here in 2022. When you didn't respond until this objection. And you can't now attack the judgment because the court rule says you can't do it this way. And so I have to deny your motion. Okay?
Mhm.
Okay, so if you want to, I don't know what the balance is on the debt, and I know you said that you had some other garnishments that took place. You can try to meet with Ms. Serby and see if you all can work something out and maybe enter an installment payment agreement or another kind of settlement agreement that will prevent them from trying to garnish your wages. So if that's what you want to do. I could put you in the meeting room now for that purpose, to see if you can come up to another arrangement so that they won't be garnishing your wages.
Okay, let's do that.
Okay,